Would you ask Mr. Cowup to come back in, please? Thank you. Good. All right, Mr. Cowup. All ready to keep going? Yes. Thank you, Mr. Kinnear, when you're ready.
Thanks, sir. Good afternoon, Mr. Cowup. During the morning session, we addressed an email from Louise Upton of the 1st of July 2013, in which she said that she had, quotes, detailed comments, particularly the first section when hazards are identified in relation to the draft GRA, and she said you'd deal with those later. Were any comments regarding hazards and their treatment in the draft GRA 3.2 communicated to you either from Louise Upton or by Mr. Britsman or indeed anyone else from CLG?
Not to my recollection, no.
Thank you. Now, can I turn to a further meeting that you had with Mr. Britsman on the 28th of November 2013? Now, first of all, am I right in understanding that there was, in fact, a meeting on that date? Can you remember now?
Off the top of my head, I can't remember. If you're going to show me a document that suggests it, I'm very happy to agree to it.
Well, let's just take it. There's a suggestion that one was due to be set up. If we can go to an email, LFB00102592. It's an email from Philip Morton to you. Suggests a meeting on Thursday the 28th of November with Les Britsman at his suggestion. Can you recall whether it took place?
I would imagine it would have done, but I can't say with complete certainty.
But it's not a meeting that sticks in the mind for any reason?
Well, without knowing the content of it. Maybe the content.
No, I was hoping to find that from you, but
oh, sorry.
That's the reason I'm asking the question, Mr. Catt.
No, in that case, I'm sorry. I'm afraid I can't really help you.
Thank you. Can we deal now with final discussions before publication, and particularly concern over lack of consultation concerning the substance of CLG's changes?
Mm-hmm.
Now, the final version of GRA was finally published in February 2014. Would it be correct to say that one final issue that was discussed before publication was that of consultation, and specifically whether it was a matter of concern that the draft GRA had not been subject to any further consultation following the last round of changes, etc., made by CLG, which culminated in November 2013? Is that a fair summary?
Possibly. I don't particularly remember such a conversation in that particular time scale. I was generally concerned about that issue, as you know. Whether it come to any kind of head or it got resurrected after Christmas, I can't really say for sure.
If we can look at some of the contemporaneous email correspondence, which don't fully address it, but I'd be grateful for such help as you're able to provide.
I'll do my best.
Can we look at LFB 00087404? Now, just in general terms, just so you know what we're looking at, it's an email thread between Melanie Gillett, if that's how you pronounce it, of CLG, Philip Morton and yourself. And if we can go to the end of page 2, this is the starting email of the chain, and you can see that Melanie Gillett asked for confirmation that the final version of GRA 3.2 had been the subject of consultation with, quotes, the usual list of consultees. We then see a reply from Philip Morton, it's on page 1, sent on the 6th of February at 12:46 hours, and he says, quotes, this document has been extensively consulted upon with all the normal consultees and many more in addition. Then if we go further up, we see an email from you which says this, Mel/all, in addition to what Phil says below, all of which I can confirm. I would also make clear that the published version has, of course, been changed by CLG CFRA from the version that was consulted on nationally with other fire and rescue services, staff side, open brackets FBU, close brackets, and other interested stakeholders. I don't believe any of these amendments have detracted from the original in any way, but when these changes were being proposed and made, I did caution Les Britzman about the implications of making any significant changes, as this would be outside the normal GRA consultation process. Now, I think, taking a step back, this confirms the evidence you gave this earlier today, and indeed resonates in the email correspondence you had with Les Britzman. But is the effective point you're making here that consultation ended in September 2012, and if any amendments are significant, then that may well trigger the obligation to consult further?
Absolutely.
At this stage, had you formed the view that the amends that had been made late in the day by CLG were essentially minor, and so there was no further obligation to consult triggered?
I didn't feel they introduced any significantly new material. They obviously highlighted stay put for good reason, and they refined issues as we discussed this morning. But I didn't feel my personal view was that the overall substance of the document had not been significantly changed.
You've been very helpful in setting out your view with the benefit of reflection and with hindsight. With that benefit, do you think the changes were such that there ought to have been a further round of consultation, given the nature of the changes? I'm thinking about the particular points about stay put that were included in the FSG section.
I think it's always good practice to be open, transparent, and for a document to have integrity. So if you've consulted on something, you then publish something different, those that were consulted upon, there's always a risk that they might cry foul, and they may have an issue that you don't envisage, but they've got an issue with what you've published. My judgment, because again I was still batting for this to be published, my judgment was that the changes CLG had made would not elicit such a response. However, such a response was possible. So I perhaps take the opportunity to repeat what I said earlier. I am mystified even more now I've seen the correspondence that I've seen, why those comments weren't brought forward, in my view, prior to the national consultation phase, i.e. June, July 2012 would have been the absolutely right time to bring all those comments forward. They could have then gone in the version that went out for national consultation, and all of those risks and issues would have been avoided.
Thank you. We're now going to leave GRA 3.2 and move to PN 633.
Okay.
Now, you have stated in written and indeed in your oral evidence that you were not directly involved in the review process of PN 633, except in respect of your role as an Assistant Commissioner with responsibility for operational policy. Is that a fair and accurate summary?
It is.
Thank you. Is it correct, though, that you were ultimately responsible for the content of 633 in your position as head of operational policy?
Absolutely.
And specifically, you were responsible for the version of 633 that was in force on the 14th of June 2017?
Yes.
And that version was published in June 2015, whilst you were still the head of operational policy?
That's correct.
Thank you. Now, you've explained in your witness statement, and very helpfully over evidence over the past 2 days, that the review of 633 was in hand whilst the drafting of GRA 3.2 was taking place. Is that, again, a fair summary?
I think it is, because as I think I said in my statement, there was a very close and sort of symbiotic relationship between the two documents.
I can stop you there just so that we can see the reference in your witness statement. If I could ask you to go to LFB 00119849/3, and if we can look at paragraph 6 in particular at the bottom of the page, you said there, my review, and that's the review there, I think, of GRA 3.2. has also highlighted to me the interconnectedness of the development of GRA 3.2 and LFB's PN 633 over the course of 2011 to 2015, the extent of which was not conveyed sufficiently in my original report. The symbiotic manner in which these two documents were produced meant that the processes applied to the development and review of PN 633 were not, in practice, as linear and compartmentalised as the process chart provided in Appendix 3 to my original report indicated. For example, a large number of the lessons identified from the Lacknell House fire were incorporated into the version of LFB's PN 633 that was published in November 2011. This document influenced the initial development of GRA 3.2, and then the outcomes of research and consultation for GRA 3.2 fed back into the subsequent version of PN 633 that was published in 2015. All of this meant that there was not a conventional one-way flow of information from national guidance into LFB policy. Now, that paragraph, does that convey the nuances you'd want to communicate to the panel about the policy development process that determined 633?
In broad terms, yes.
Thank you. So to be clear, there was a revised version of 633 that was published in November 2011.
Correct.
And following a review as a result of the Lacknell fire.
Correct.
And a further revised version was published in 2015, which reflected in turn the published revised GRA 3.2.
Correct. I think, to be complete, there was an interim version in 2012, 2013, which I think covered some administrative issues. It's covered in the tract. I think I'm right in saying that. I may be wrong, but I think there was an interim version, but it was as a result of other policies changing their name or designation. So it was an administrative change. It wasn't a substantive change.
I'm grateful. Now, the first topic I'd like to discuss with you is the general process for policy development at the LFB. Mm-hmm. Now, Appendix 3, which you referred to there in paragraph 6, is one of the appendices to your report PC6, is that right?
That's correct.
And it contained a flowchart that summarises the LFB's standard process for producing new operational policy or making amendments to existing policy, is that right?
That's correct.
Now, if we can go to Appendix 3, it can be found at LFB 000 32813/2. And is that the Appendix 3 you're referring to in your paragraph 6 of your third witness statement?
Indeed.
Now, the first column on the left-hand side sets out the different, quotes, drivers for change, close quotes. Is that right?
Yes.
And these are the events that may be external or internal that trigger action by the operational policy department. Is that right?
In a general sense, it's not meant to be absolutely exclusive. There could be other events. This was something I created because there was no agreed process when I took up the post. So I created it to try and bring greater consistency, and it was very useful for people joining the department to have something very clear to follow.
And you produced this in 2010 or thereabouts, would that be about right?
I think the first version was as early as that, yes. It's been changed many times and adapted and improved, but yes.
So what iteration of the flowchart is this? Is this the last one you had whilst you were still in post?
I think because I added it to the report that I'd been asked to write, I think I probably added the version, it says in the top left-hand corner, final version, January 2019. It's likely this is a more up-to-date version than when I was in post.
You left in March 2016.
Correct.
With whom did you consult to ensure that this captured developments over the later 3 years?
I took it as a document. It was the current version, I think, that was available at the time the report was written. I think, to be fair, the changes are relatively minor.
Thank you.
I don't think it's substantially changed in that time, but I think, for example, the delivery and communication strategy might not have been there at the beginning. For example, that's one
Thank you.
possibility.
And that delivery communication strategy is in the column on the far right-hand side, is that right?
That's correct.
Thank you very much for that clarification. Now, can we look at the far left-hand side column? And the examples of the external drivers are set out in the top subheading in that column, and they include legislative change, national directive, and so on. And the introduction of a national generic risk assessment would also be a generic driver, is that right?
I think I would have interpreted that to be a national directive. It's nationally produced guidance.
Thank you. And looking further down that column, you give examples of internal drivers, including the DIOT process, which we heard about in Module 5. Can you explain the type of drivers that might be identified by the DIOT process that would in turn prompt action by the operational policy team?
So the DIOT process reflects issues identified via performance review. So the Brigade's operational review team, for example, the outcome of performance reviews of command or performance reviews of operations, debriefs, operational learning. The idea of the DIOT process was to bring that into a kind of systematic approach so that the learning was captured and then applied as necessary. And if you look at this in terms of a safe system of work, the risk assessment and the policy should always be the headline event. So if something has been perceived as a gap or as a deficiency, the first place that the change should happen is in the risk assessment, then the policy, and then that is used to specify training and possibly equipment.
Whose responsibility was it to ensure that the internal drivers were identified and acted upon by the operational policy team?
I think I'm right in saying the DIOT process was owned by either Gary Reason as the director or possibly Danny Cotton as the Assistant Commissioner Operational Assurance, because most of the legwork for DIOT was done in her department or by her staff. For example, the operational news, that closely reflected what was going on in DIOT. So in terms of that part of it, that would be either Danny Cotton or Gary Reason. The introduction of new equipment and procedures. Well, procedures would normally be ops policy, but we only owned around about 80% of LFB's operational policy. So there's quite a large percentage is owned by other departments.
You say only 80%.
Well, so I think that equates to around 190 documents
Now,
of a total of 230 documents.
so looking at the 20% that wasn't owned by you, could you give the panel an idea of the subject areas or activities that were subject of policies that you did not own?
Yes. Incident command, that was owned at the time by operational assurance. Anything relating to transport or terrorism or I was going to say contingency planning, emergency planning in its broadest sense, that was owned by operational resilience. There's a few policies owned by service delivery. The easiest way for the absolute facts is if you look at my report, it's detailed in there.
It was just, I didn't want to go
Yeah,
too
in
many
pure
points.
numbers, it's detailed in there. So service delivery, which was Dave Brown's department at the time, they owned a few. Regulatory fire safety owned some as well. So the phased evacuation policy, which is one that you might well be interested in,
Yep.
was actually owned by regulatory fire safety.
Thank you. Now, looking at the particular example of a national or new national generic risk assessment, whose responsibility would it be to be aware of the fact of it and its content and the consequences for LFB policies?
So at that time, that was me. So I was the point of contact. I received them. A large number of them were for operational policy to deal with. So I would just pass them to the team member. But where they cross those departmental boundaries that we've just discussed, I would pass them to the relevant head of service.
Thank you. Now, going back to the table, the next column along from the left is risk assessment, and that's the next stage of the process. Is that right?
Correct.
And risk assessment is a specific document that is generated in order to form the basis of a new or amended policy. Is that, at least in broad terms, correct?
That's absolutely correct.
And if we look at the text immediately under the subheading risk assessment in that column, we can see that the risk assessment is designed to identify, quotes, hazards, risks and control measures to be implemented within the policy. Is that right?
Yes.
And who is responsible for preparing the risk assessment?
It would be the responsible team that are dealing with the policy. So it should be their first step towards creating or amending the policy.
So in relation to incident command, presumably that would be operational assurance?
Correct.
And in relation to 633, it would be your department?
Correct.
Moving further towards the right, we look at the third column, and that's entitled Procedure Development. In broad terms, that's essentially the drafting process. Is that fair?
Indeed.
And is it correct that the drafting of the policy is carried out by the Operational Policy Department, or would it be done by the responsible department? So, for example, in Incident Command, it would be done by Operational Assurance.
The responsible department.
So for 633, it's you.
Correct.
And is it correct that there are different teams within the Operational Policy Department who take responsibility for different subject areas?
Yes.
Can you give us an idea as to how the team is divided across those various subject areas?
I can certainly give you an idea for how it was when I was there. I'm conscious it's changed more recently.
Please do. Just I'm only going to ask you to speak to matters when you were at LFB.
I understand that. I just don't want to mislead the inquiry about where we are now. So when I was there, there was a fire team who dealt with anything relating, obviously, to fires, both in buildings and not. There was what was called an operational support team. That was all the support appliances like hose laying units. I think they dealt with aerials, bulk foam units, appliances like that. So that was more appliance based than incident based. There was a rescue team who dealt with urban search and rescue and the functions performed by fire rescue units. They also dealt with international search and rescue, which is a version of urban search and rescue, but when there's an international deployment. And then there was a hazardous materials team who dealt with incidents involving chemicals, biological risks, radiological and nuclear.
So CNBR.
CBRN, yeah.
CBRN. Fire team, would they have been...
No, sorry, not CBRN. So CBRN was treated as a terrorist issue, so that would sit with operational resilience.
Thank you.
We would advise on the technical side of the hazmat element, but it's because it's a deliberate act, it was counted as being a terrorist issue.
Fire team, would that team have responsibility for 633?
Yes.
Now, you referred to in an earlier answer there to advice and support you give to other departments. So, for example, if operational assurance sought your advice in relation to a policy which affected incident command, you'd have the expertise to be able to assist. Is that a fair summary?
I mean, it would be very context specific and dependent. So I think I'd need to know in what.
I was just asking a general term question, Mr. Cowup.
In general terms, we were a big team. You know, we were little teams, but we were a big team. So of course we would assist each other But you asked me whether we had the expertise to do that would depend on the topic and the issue.
What degree of oversight of the drafting process, so I'm thinking of policies that fell squarely within your directorate's responsibility, did you have as the head of operational policy?
So the oversight worked at a number of different levels. Pardon me. So the drafting work was generally carried out by someone at station manager level or assistant divisional officer level if you're in that rank structure. The immediate oversight was provided by a group manager or divisional officer, but sometimes they would also do the drafting. The next level of scrutiny and support was at DAC level, and then myself, I don't think there's a policy that was produced when I was there that I didn't at least look at. Did I always scrutinise them line by line? No.
And would the depth or degree of scrutiny depend upon the complexity of the subject matter or its sensitivity, or frankly if it considered matters which had been vexed to deal with previously?
I think it would have all of those things and more. So if, for example, it was an amendment rather than a new policy, then I would probably give that a very light touch, because I trusted my staff, I had a good team, and I was confident that they would do their job. And in particular, I would look to the DAC to assure me that the document was where it should be.
Thank you. Now, going back to the flowchart, if we can, the fourth column, reading from the left, is entitled Stakeholder Consultation. Now, that appears to set out a number of different forms of consultation. And could we go through them briefly together? The first is peer group review. And it's said that this, quotes, may include end user as a key stakeholder and involve procedural testing arrangements such as operational exercises and use of the operational sounding board.
Yes.
For these purposes, who are the end users?
So, the end users of an operational policy are firefighters and on fire stations and officers that either perform incident command or sector roles.
Thank you. So as part of this stage of consultation, what you're essentially seeking to establish is how the proposed policy would work in practice. Is that a fair general description?
Very much so. The list of possible options there, I think it'd be useful for the inquiry to appreciate that they were suggested ways of achieving that outcome. So I wouldn't expect every policy to be subject to an operational exercise.
So that's what I was going to ask you next about operational exercises. When would they be considered most appropriate for testing a policy, as it were?
From my perspective, it was when you were doing something where you really wanted to be sure it was practicable. So we did it for high-rise, for example.
That's what I was about to ask you. That's a paradigm of a policy that would be subject to an operational exercise.
Absolutely.
Who's responsible for deciding whether an operational exercise is the appropriate mode of consultation?
That would be the judgment between the policy author and the group manager and possibly the DAC and possibly me if they felt they needed to bring it to my attention. If, for example, it was about resources, getting the remainder of the organisation to commit to it, I might be able to facilitate that for them.
They need it when they needed heft?
Possibly.
Who was responsible for designing the operational exercises?
But I only did it for a few policies, and the way I did it was by identifying an event that was already scheduled. So in the case of high-rise, somewhat ironically, then the same names keep coming up. Andy Rowe, who was a station manager at Southwark Fire Station, and I knew him very well because I'd known him from when he joined. I knew that he was organising quite a significant high-rise exercise, so I approached him and said, there's a new version of, and this was, I think, the version of 633 that was published in 2011, just so we're clear. And I said it would be really helpful because it's got new content regarding evacuation, fire survival guidance and so forth. It would be really helpful if we were to trial it in a practical setting, and would you mind us using your exercise as a vehicle for that? And he was really happy to do that as the exercise director, and so that's how that one played out.
For the purposes of the 2015 version of 633, did you design the operational exercise for that policy?
I'm pretty sure it wasn't subject to one.
So it may well be I'd misunderstood you.
Yeah, because I think the exercise we used was for the what became the 2011 edition, because I think that exercise was held in around about June 2011, if I'm correct.
And so, just for the avoidance of doubt, no exercise was carried out for the 2015 iteration of the policy?
Not to my knowledge, although there were regular high-rise exercises. Would Pat or Jim McCourt have done it, and I possibly wasn't aware? They could have done. I wouldn't rule it out, but I wasn't aware of it.
But the question might be better directed towards Mr. Utting tomorrow, maybe.
As a confirmation, for sure, yeah.
Now, the second form of consultation set out in this particular column is training impact assessment. And the text here states complete required sections of TCAP and forward to training and professional development, T&PD, for review and comment. Now, we've heard evidence in Module 5 from Peter Groves about the TCAP process itself, but just to recap, in broad terms, it's the formal request process for training submitted by the petitioning department to the training department. Is that right?
Correct. And I think in the context it's written here, that training and professional development department was an LFB department, so this is prior to it going to Babcock. This is to make sure that, in process terms, the form has been completed correctly.
And also in this context, that request would be a need for training that had been identified by the Operational Policy Department.
Yes.
Say in the context of 633, as a result of the creation or an amendment to an existing policy.
Absolutely.
In other words, where the work carried out by your department on a new policy had identified either a new training need or as a result of a new policy or a new one as a result of an amendment, that would be done by the Operational Policy Department making a formal request by completing the TCAP form.
Yes.
And that TCAP request is then the beginning of I think the euphemism was continuing dialogue between the Operational Policy Department as the commissioning entity and the training department itself.
That's correct. It would also normally involve service delivery or fire stations, Dave Brown's department. So we tended to get them involved at an early stage because they were going to be the people responsible for delivery. It might also involve other departments if there was a good reason for them to be involved.
Now, who within the Operational Policy Department would be responsible for completing the TCAP form when it fell to your department to be the commissioning function?
Generally the policy author.
Is it fair to say that rarely, if ever, would it lie to you to initiate the TCAP request form process?
I don't think I ever initiated a TCAP.
Can you give the panel an idea, maybe useful in the context of 633 to give it a specific context? What would be your involvement in the process of developing the necessary training with the training department?
I didn't have any direct role at all, other than in a general sense. I used to meet with Peter Groves periodically, and without getting into the detail of any particular commission, we would review all of the commissions that my department had initiated, with a particular emphasis on any that were showing either amber or particularly red, to see what the problem was and to see whether there was anything that we could do or that I could do to unblock any problems.
Amber or red being the traffic lights indicating
Yes,
delay.
the RAG system.
Delay. Just let me finish the question. With indicating delay in implementation of training, is that right?
No, indicating a delay in the development of the training.
Thank you.
In other words, the TCAP process itself.
Going back to the flowchart, the third form of consultation here is CO's impact statement. First of all, who are COs?
That's a really good question. and I'll be honest, I think that may be an addition that was made after I retired, because I right now, I can't remember.
Moving on. Below that, there's formal heads of service, AC consultation. It's the final subheading I'm looking at now.
Yes.
At this stage, the draft policy is at the stage where it's sent to heads of service. Is that right, as its title indicates?
That's correct. And that when I was there, that used to go out in my name via my personal assistant, used to send that out, and there was a standardised set of text that went with it to invite people to comment and to explain how we would like the feedback to be provided.
When you were one of the consultees for this process, the head of service, would you essentially receive the request and then staff it down to whoever knew most about it?
Generally, yes.
Looking at the fifth column, that's entitled Representative Body Consultation. Am I right in understanding that is consultation with whoever the LFB is required to consult, so primarily trade unions, presumably?
Yes, the representative bodies is the trade unions, yeah.
Thank you.
Primarily Fire Brigade Union and the Fire Officers Association, but also the FRS staff trade unions, Unison and GMB, were also represented, and in some cases had a legitimate interest in an operational policy because some of the policies affected their members. But it was mainly the FPU.
And the final but sixth column is entitled Delivery, and that involves essentially further communications with the training department to agree training options. Is that a fair summary?
Yes, that was pretty much the final stage, was how is this training actually going to be delivered?
And part of that presumably would involve final communication to the subjects of that training.
Yes, I think that was the next stage, the delivery and communication strategy.
That's why I said this is what it involves here.
Yes, absolutely.
Thank you. Can we now, having dealt with the structure, turn to the review of 633 itself? Now, you explain, and if we can go to it, it's probably easier, your third witness statement, which can be found at LFB 00119849/84. And if we could look at paragraph 188 of that statement, which is at the bottom of the page, you said this. As the consultation periods for GRA 3.2 were largely completed in 2012 and 2013, work commenced on updating PN 633 to reflect the new hazards identified in the GRA 3.2. I asked Pat Utting to take the lead on this, and for the early stages of this work, he was assisted in this work by Phil Morton. Now, it's that particular period of review I'd like to discuss with you this afternoon. Now, you've exhibited to your statement an email that you sent to James Accord on the 15th of January 2013. And could we go to that? It's at LFB 0085313. And if that could be expanded. Jim, further to our recent discussion, please find attached the final draft of the new high-rise National Generic Risk Assessment, GRA. This document has recently been sent to the GRA Programme Manager, and it will be passed to CLG for typesetting in due course. This may result in some formatting changes, but will not change the content of this document. As previously discussed and agreed, I would like you to coordinate a review and amendment of LFB's PN 633 to ensure that it is consistent with the attached GRA. As mentioned earlier, this work would normally fall to the fire team, but I've asked you to do it in order to balance workloads and to promote greater team integration and cross-working. I would also ask that this review has regard to identify any issues and lessons learned from the Lacknell inquest, which you will know has just started and is due to run until March. Station Manager Morton and myself, as GRA authors, have tried to ensure that the issues arising from this incident, as these were understood prior to the inquest, have been incorporated into this GRA. But you will appreciate the need to check that nothing new or different arises during the inquest itself, which would have a bearing on LFB's approach to what we do when tackling fires in a high-rise building. I would anticipate that the timescales for this work and the inquest will be roughly aligned. The LFB high-rise risk assessment will also need to be updated and a TCAP drafted to ensure the changes are properly reflected in training. If anything is unclear, please don't hesitate to ask. And just looking at that draft, when we were talking about how you allocated policy work internally, it felt 633 fell to the fire team. Was Mr. Acortt part of the fire team or not?
No, he wasn't. His lead was incident communications. And when you asked me earlier for the breakdown of teams, I forgot to mention him, but that's because he originally sat with Danny Cotton in her department, and then at some point, and I can't remember when, he came across to operational policy.
Did he have a particular expertise or experience of fighting fires in high-rise buildings? Was that why you chose him?
He's a very experienced fire officer, as was Pat Uttin. He was also part of the ops review team, so he'd attended a very large number of incidents. So between him and Pat Uttin, yes, I would say they were both had relevant experience and knowledge.
Were those the particular reasons why you picked these two officers?
Yeah, in large part, I would say so, yeah.
Because clearly fighting fires in high-rise buildings was a subject of interest and sensitivity. Presumably that informed the choice of the individuals you made who were going to lead the work on revising 633. Is that a fair assumption to make?
It is, and because I knew Pat Uttin would be the person holding the pen, I was always quite impressed with his work. He was a very competent station manager, very experienced station manager. I also wanted Phil Morton involved, knowing that he was about to leave the department, but I wanted to provide a degree of continuity between what we've done or what we had done in the GRA to make sure that was carried across into LFB's policy.
Thank you. And so essentially you were content you had a trinity of safe pairs of hands there?
Not quite sure I'd have described them as a trinity, but they were safe and effective.
Thank you. Now, we've already seen that in relation to the review of GRA 3.2 that a number of amendments were made to the draft after your email to James Acortt in January 2013, and we looked at those yesterday. In relation to the review of 633, though, was your intention that Mr. Acortt would keep abreast of developments in the drafting of 3.2 and would ensure that those were incorporated within 633? That was going to be his responsibility.
Yes, it was, and my recollection is that as and when I received any new versions or new drafts, that I shared them with him, and I think you've seen him copied into some of those emails. And indeed, I think I shared them with Pat Uttin as well.
And essentially there were two streams of work which Mr. Acorte had to be alive to. One, GRA 3.2, but also what may come out of the Lacknell inquests when they were completed.
That's true in a technical sense, but in practical terms, my view at this time was that nearly all of the work had been done. GRA 3.2, I was blissfully unaware of CLG's darkest faults, but beyond that, I didn't actually think this was going to involve too much work, if I'm honest, because the GRA was written in a way, one of the very criticisms of it was too procedural, so it's not unreasonable to say it was going to fit fairly well into the LFB template.
So it's capable of being translated into operational policy without too much difficulty.
That was my view, very much so.
Could we now go to an email from Mr. Acorte to Patrick Utting that's sent on the 2nd of April 2013, into which you were copied? It can be found at LFB 000-86677. Thank you. And if we could look at the second email from the top, which was sent by Mr. Acorte on at 9:37. Thank you. And in that, he says this: Pat, I've had a quick word with Peter Cowup with reference to the high-rise GRA and the LFB policy. It's something that we will lead on for ops procedures, and Peter is likely to talk to you next week on your return from leave about it, in my absence, that is, as I won't be back until Wednesday the 10th. Could you do some preliminary work on this, and involve Dave too, as he has carried out much of the assessment in terms of policy gaps based on national GRAs? I'm sure Peter is able to put the requirements across more eloquently than I have in this slightly rushed email. You then reply in the top email of this thread saying this: Noted, Banks. Pat, can you put a 30-minute slot in our diaries for next week and invite Dave along as well? I would also like Phil M there, so that's Philip Morton, to be there, as he's done a lot of the work on this GRA. Peter. Now, it appears that a meeting was then scheduled for the 10th of April 2013, and if we can go to LFB 000-86676, that could be expanded. That's entitled Lacknell Verdicts, and a meeting of the recipients of, or the directed addressees following your email.
Yes.
And its purpose to discuss Lacknell outcomes with reference to high-rise GRA and LFB policy. Again, with apologies for asking you a question about a meeting that took place 8 years ago, but can you remember if that meeting took place?
I'm afraid not with absolute certainty. What I would say, looking at the title,
Yes.
and also looking at the attendees, in particular Lee Drawbridge, that this may have been more focused on, was there anything new coming out of the inquest, the formal findings of the inquest, rather than talking about 633 development more generally.
So it wouldn't have been the meeting, for example, when you instructed Mr. Utting, for example, to carry out the work on 633.
Looking at the title, I can't say for sure, but the title tells me it was probably more about the substantive issues coming out of the Lacknell inquest.
Can you remember now specifically what you asked Patrick Utting to do in relation to a review of 633?
Yes, I think in broad terms, I asked him to, I think we spoke about a gap analysis, and then I think what I said to him was that I foresaw this as a relatively straightforward task of bringing across the relevant elements of the GRA into LFB policy, recognising that there are sections of that GRA, for example, relating to training and competence, which would not form part of an operational policy. But that aside, the sections that did form part, I felt were largely almost a cut and paste into LFB policy. But there are exceptions because it was written generically for fire services nationally. So where there was an LFB specific I would obviously expect Pat or Jim or whoever was going to do the writing to pick up on that and to put in the LFP specific elements.
So it's slightly more than a cut and paste job, but not substantively more. For example, it wasn't a root and branch review of high-rise firefighting policy and procedure.
Correct.
Can you remember, given the distance of time, whether you specifically instructed Mr. Utting to review the Rule 43 letter that had been addressed to the LFB arising out of Lacknell?
I don't recall specifically instructing him to review it, but as has already been shown in the documents we've seen just now, I made it clear that we had to make sure there was alignment between what was coming out of the Lacknell inquest and what we were going to put in our policy.
Beyond that general instruction, did you deal with, or did you give Mr. Utting a particular instruction, for example, to examine the coroner's recommendation that incident commanders be trained to anticipate that a fire may behave in a manner inconsistent with the compartmentation principle?
No.
Can you help us as to why not, given that had been obviously a source of some discussion and controversy at the inquest?
Because I guess I'm reflecting on it now. I just felt that he would have. My expectation is that he would look at the verdict and look at the document and bring across what was relevant from it. And I accept, given the discussion we've had in the last 2 days, and I've already accepted that was an omission, and I think that carried through into my briefing. So to answer your question, my briefing to him could and should have been probably a little bit more specific.
Thank you. Could I ask for your help to resolve an inconsistency or an apparent inconsistency in the evidence? In relation to the Lacknell recommendations, Mr. Utting has said in his witness statement, and we don't need to go to it, but the reference is LFB 00118918/16, paragraph 62, that he was not responsible for reviewing policy 633 following the inquests. Now, that jars with the evidence that you've given, that is precisely what Mr. Utting was tasked to do. Can you help us, or help the panel, resolve that particular tension?
I can only think. I mean, I've not really picked up on that before, so I haven't had a chance to.
Would you like to look at the extract from Mr. Utting's statement?
It might be helpful just to see the context of it.
Of course. Apologies, this is... the document manager will be bringing that up now, with apologies to him. It's paragraph 62. Quite a stark statement there.
If it helps the inquiry, my first thoughts, and I haven't discussed this with Pat obviously, and I haven't had a chance to really consider it in detail, but I suspect what that may relate to is that Pat would have probably known from talking to me and talking to Phil Moulton that the vast majority of the changes associated with Lacknell had been made to the November 2011 document, and that statement may reflect that understanding. I accept that's not what he's saying, but you've asked me to offer a view, and that's the best I can offer at this moment in time. I think Pat would be better placed to explain that or expand on it if you need him to.
I'm grateful. Thank you, Mr. I invited you to assist us, and you have done, so don't worry.
Without pondering it further, and if I do and I think of something different, I'll let you know, but that would be my interpretation of what that might mean.
I'm grateful. Could we stay with Mr. Utting's statement, go back to page 14 and paragraph 55? The question was, who supervised you in relation to this being the work on revising 633? And he says this: I was supervised by Jim Acourt, DAC Kevin Hughes, and AC Peter Cowup. Would you agree that he was supervised by Jim Acord, first of all?
Yes.
Was he supervised by DAC Hughes?
To a lesser degree in terms of granularity and day-to-day contact, but yes, he, in terms of his line management chain, I would say that answer is a better description of his line management chain. In terms of supervision, by which I would mean day-to-day management support, that was very much Jim Acord, probably to a lesser extent Kevin Hughes, but equally I always had a kind of open door policy, and I was always very happy to speak to people. So it's quite probable, in fact I'm pretty sure we did have face-to-face conversations. So to that extent, you know, I'm quite happy to be seen as his supervisor, but the direct supervision was carried out below me.
And for these purposes, we shouldn't, or the panel should not read that degree of supervision as being synonymous with the fact that you were directly involved with the preparation and revision of 633.
Correct.
Can we now turn to a new topic, which is the gap analysis that Mr. Utting carried out?
Okay.
Now, he carried out that analysis, or he says he created it, carried it out to identify and to assist his review of 633 to identify gaps that needed filling. And if we could look, stay on his statement and look at paragraph 54, so it's on this page, but the sixth line down from the top. And it starts with GRA 3.2 is divided. Do you have it? 6 lines down. Sentence starts on the right-hand side.
Yes, indeed, yeah.
Thank you. Sorry, it's a long paragraph. GRA 3.2 is divided into 2 sections. Section 1, providing a narrative, and Section 2, a tabular risk assessment. In conducting the review of PN 633, we referred to the risk assessment in Section 2 of GRA 3.2 and the list of hazards. The risk assessment in GRA 3.2 had been the subject of scrutiny and national consultation, and we felt it was a good risk assessment to work from as a starting point when identifying the hazards presented in high-rise firefighting. We undertook a gap analysis between the risk assessment in Section 2 of GRA 3.2 and the version of 633 extant at the time of the review. We cross-referenced the GRA 3.2 risk assessment at Section 2 with the then current PN 633 to check that every hazard that was in the risk assessment was also in PN 633, where we identified hazards and therefore risks and control measures that were not in PN 633. We added these to the draft we were working on. Now, just before I go further, the "we" that Mr. Utting adopts there is a reference, it would appear, to Phil Morton, with whom he was working at least at this stage in the process. Does that sound right?
That's absolutely the case, and as I said earlier, I'd asked Phil to work with Pat in the early stages to provide that continuity and to ensure a free flow of information.
Thank you. Could we now go to your third witness statement? LFG...
Sorry, before we do,
yes, of course.
Could I just, for the inquiry's benefit, could I just clarify that what you've got in Section 2 of the GRA is not a risk assessment, and the reason for that is it's not scored. So the difference there is it's impossible nationally to assess the risk unless you know which of those control measures will be applied. So the matrix was very much an assistance, but it wasn't a risk assessment. And I mention that because a lot of people were forever confused about that. And you know, so when Pat says it was a risk assessment, he's right. It was a risk statement, I think, is a better way to describe it.
A valid distinction to draw, thank you. Can we go to your third witness statement, though?
Yes.
LFB 00119849/92 and paragraph 207. Thank you. Looking at the first sentence of that paragraph, Mr. Cowup, to help ensure that consistency was achieved, I requested that a gap analysis be undertaken between GRA 3.2 and the version of PN 633 that was current at the time. Now, bearing in mind that, do you think that the gap analysis that you say you requested be undertaken is the same analysis that Mr. Utting carried out?
I would assume so, yes.
Now, in his second witness statement to the inquiry, Mr. Utting confirmed that this gap analysis that he carried out was recorded in a document which he's provided to the inquiry. Mr. Utting confirmed in his second witness statement that the gap analysis document was last edited by him in May 2013. And if we could look at that analysis, please, and it can be found at LFB 00121174. If that could be expanded slightly. Mr. Cowup, is that document familiar to you?
I think it's fair to say I probably had sight of it. I'm certainly not familiar with it in detail because I didn't play any part in this work.
It wasn't something that you needed to apply your mind to in any detail, is that fair?
No, as I've said already, I had complete trust in Pat and Phil.
If this is the gap analysis that was produced in May 2013, would it not also be the case that the gap analysis could not have captured the significant amendments made to the evacuation and stay put elements that were introduced as a result of CLG's interventions into GRA 3.2?
That's a fair observation.
And indeed, the gap analysis must by definition proceed upon an earlier draft of GRA 3.2.
Indeed.
Now, can we look at some of the points that Mr. Utting makes in his analysis and be grateful for your assistance on those? Could we go to page 3, first of all, which is the section that considers planning? Now, on page 3, we see the same reference to contingency plans towards the bottom of the page, which reads, as we've seen in the various iterations of the drafts of 3.2, contingency plans should include a range of events which are foreseeable for the particular premises, including fire spread beyond the compartment of origin and the potential for multiple rescues. Now, we know from the documents which have charted the drafting process of 3.2, which we've been through, that CLG expanded this particular text. And if we could keep this on the page, but also put alongside it LFB quadruple 01255/19. On the right-hand side, as we looked at earlier this morning, we can see the second bullet point from the top says an operational plan being required in the event the stay-put policy becomes untenable. I'm making no criticism, Mr. Cowup, but just asking for your confirmation. That second bullet point, which is in the draft GRA,
It's not in the gap analysis.
Thank you.
Totally accept that.
Do you think the likely explanation for the absence of that second bullet point in the gap analysis is that the gap analysis was not updated after CLG's amendments were made and after GRA 3.2 was finally published in February 2014?
Is this the only version of the gap analysis that you've
Yes,
given?
that's our understanding. And also we have Mr. Utting's evidence, as I indicated slightly earlier on, that the last time this was amended was in May 2013.
That's a fair conclusion to draw then.
You can't think of any other explanation. That's the reason I put it to you.
It could be that Pat felt that because the number of changes post this point, i.e. post May 13.
13.
Because I think when he did this gap analysis, Phil and myself would have shared with him our relative confidence that we were looking at what was probably close to a final version. It may be that the subsequent changes that were made by CLG in the way that we've discussed extensively before, he chose to bring them into the policy or not without updating his gap analysis. That's possible. But
Something
I think
we can investigate with Mr. Cowup, but there's no reason that you can definitively speak to as to why the second bullet point, as set on the right-hand side, is not in the gap analysis.
no.
Thank you. Now, there are two other references in the published version of GRA 3.2 that don't appear to have been picked up in the gap analysis, and I'd be grateful for your assistance in relation to those 2 points. Could we keep both documents alongside each other for the moment? In relation to the right-hand side document, could we go to page 21, which hopefully is the competence and training section of the document? And we've looked at this previously, and we see the final subheading on that page, just above the 3 bullet points, says this: training which will cover high-rise incidents must include. And then if we go over the page, we see the 4th bullet point from the bottom of that list: evacuation and casualty removal tactics. Incident commanders should understand when a partial or full evacuation strategy might become necessary in a residential building where a stay put policy is normally in place. Now, if we can look at the gap analysis, but go to page 4 of it, and the middle paragraph in particular, and look at the second sentence, which starts, fire and rescue services should consider both generic techniques for persons told to stay put as well as bespoke arrangements for specific buildings where this is appropriate. Would you be able to confirm for us that there's no reference there to the need for incident commanders to be able to understand when a partial or full evacuation strategy might become necessary in a residential building where stay put is normally in place?
I can, and I guess the same explanation applies in terms of the mismatching timing between these 2 documents.
Insofar as you're able to speak to that point.
Insofar as I'm able to speak to it, and recognising that I was not involved in the detail of the left-hand side of the work.
Thank you. With apologies to the document manager, looking at GRA on the right-hand side, could we go to page 18? And that sets out, from the top of the page, information to be gathered in relation to high-rise incidents. And the 10th bullet point on that list reads building construction features, such as the presence and location of maisonette-style construction, sandwich panels, timber framing, cladding systems. Would you agree that that also was not included in Patrick Utting's gap analysis? You can take it from me, there's no reference to cladding systems there at all.
I would fully accept that. Can I add
Please do.
a comment which may help the inquiry? So, as you can see in the GRA, the various features that we suggested people should look out for were described in terms of such as. So they were exemplars. It was not a definitive list. There's always a question when you're transposing national guidance into local policy of the need for conciseness. And it's possible that Pat Utting quite unwittingly dropped several of the exemplars when he was writing 633 without probably appreciating, particularly in the context of the tragic events at Grenfell, what that would come to signify. But at the time he did it, and I think this is very important to emphasise, he would not have been aware of the hazard, the flammable hazard posed by cladding.
Mr. Cowup, is that speculation on your part? Or do you have some sound basis?
I'm very confident that Pat Utting wouldn't have understood the cladding hazard.
That's not the question
But as to whether what I've offered as a possibility, I'm trying to help, but if that's not helpful, I'll withdraw the comment.
Well, my question is, are you speculating, or do you have some basis in fact for putting that before the panel?
That's my understanding. That's my speculation. Yeah, I accept it's speculation.
Thank you. Do you have direct knowledge as to why the reference to cladding systems was dropped was not included, rather, in PN 633? By that I mean you can give a direct account as to why cladding systems were not referred to in 633.
I'm not able to do that.
Now, in relation to cladding, you dealt with this in PC6, and if we could go to PC6, which is at LFB 000-327-83/23. Thank you. And if we could look at paragraphs 3.7.7 and 0.78 at the top of the page. And you say this: cladding was included within planning because, as an outer layer on one or more faces of a high-rise building, it was understood that the use of this material would create a void which had the potential to promote an abnormal degree of external spread of fire or smoke. 3.78. As such, cladding was noted alongside timber framing, surface-mounted trunking and voids as an example of a building construction feature that should be recorded within the information to be gathered by FRS in relation to high-rise incidents. However, at the time GRA 3.2 was produced, this should not be interpreted to mean that cladding itself was understood as presenting a significant fire hazard, and the rationale for this is explained below. Now, it's not clear from this whether you're saying that it was an informed, conscious decision not to include any reference to cladding in 633, which you took the view that there was no evidence that it presented a fire risk, or whether it simply did not occur to the policy authors to include reference to cladding, notwithstanding it was expressly referred to in GRA 3.2. Which of those two explanations accords with your recollection?
I certainly wasn't. I wasn't involved in any discussion of that issue with Pat Uttin, so any response I provide will probably be speculative, and therefore I don't suspect you'll need me to say it.
I wouldn't want to invite you to speculate.
So I certainly didn't discuss it with him. Obviously, what I've written here is with the benefit of hindsight.
You're not aware of any discussions at the time 633 was being reviewed as to whether the reference to cladding systems should be retained or removed from 633?
Absolutely not.
Were you familiar with the Local Government Association Guide on Fire Safety in Purpose-Built Blocks of Flats at the time of this review?
No, I was not.
Could we go to it, LFB 00118893? Have you seen that document before?
Possibly, but I certainly wouldn't claim any familiarity with it.
Now, it was published in 2012, so it's in circulation during the currency of the 633 review. That guide does refer to the risk of cladding systems on high-rise buildings. And if we go to page 111, this is in a section of the guide which is concerned with managing fire risk. And if we could look at paragraph 72.1 and 72.2 in particular, they say this under the general heading, external fire spread. 72.1. The external facades of blocks of flats should not provide potential for extensive fire spread. When assessing existing blocks or flats, particular attention should be given to any rain screen or other external cladding system that has been applied and to facades that have been replaced. 72.2. The use of combustible cladding materials and extensive cavities can present a risk, particularly in high-rise blocks. Restrictions are normally applied to the nature of such materials and, in particular, their surface spread of flame characteristics. Cavity barriers are also required in some circumstances. Assistance from specialists may be required to determine if the external surfaces of walls are satisfactory and whether there is adequate provision of cavity barriers. Now, would you agree that that text appears to anticipate the use of combustible cladding materials in the construction of high-rise buildings?
Indeed.
To the extent to which you can speak to this, do you know whether Mr. Acorte or Mr. Utting or DAC Hughes were aware of the substance of the LGA guide insofar as it considered external fire spread?
If they were, and they never shared that or discussed that with me.
But you don't remember it at all being referred to during discussions surrounding 633 within which you were involved?
No.
During the...
Sorry, if it helps the inquiry, this is very much the kind of material that I would have expected regulatory fire safety colleagues to draw to our attention, because as it says in the title of the document, this sat in their world. You know, they would have known about this document, I'm sure, and I would have expected it to come through that route to us.
Is it fair to summarise your evidence that you can't confirm whether you saw this document at the time, but you are unaware of the substance which I've just quoted to you?
I may have seen it, but I'm certainly unaware of this level of detail.
Going back to the meetings which you had with CLG, and I'm thinking about the discussions with Mr. Britzman about whether GRA 3.2 was doing the job which they perceived it needing to do, did they ever raise your attention to issues relating to cladding and rapid external fire spread?
Cladding, absolutely not. Rapid external fire spread, which was already in the document, we may well have discussed that in the context in which it was in GRA already. Now,
there's a draft completed after you'd received a response from CLG, added item 14 to the reference section, which was the LGA guide. And if we can go to LFB 00102513/39, that could be expanded so we can see item 14 at the bottom. Can you help us as to why the reference to the LGA guide was included here?
I can only assume it was added by CLG.
But it's not something, for want of a better phrase, you clocked at the time.
I'll be honest, I didn't pick up on that. But then, as I've already said, I never saw these amended documents. So I think it's possibly true to say that the first time, if I had seen it, I would have seen it, would have been on publication.
And so for the avoidance of doubt, you did not have regard to the LGA guide when you were drafting GRA 3.2?
No.
Thank you. So that's probably a convenient moment if it's
Yes,
convenient for you.
Well, at this point, Mr. Cowup, I think we should have a short break. So we'll stop now. We'll come back, please, at 25 to 4. And again, please don't talk to anyone about your evidence while you're out of the room.
Thank you,
All right?
sir.
Thank you very much. Right, thank you. 25 to 4. Please.
Thanks, sir.
Thank you. Would you ask Mr. Cowup to come back in, please? Thank you. Right, Mr. Cowup. All right, we'll go on. Yes, when you're ready, Mr. Kinnear. Thank you.
Thanks, sir. Mr. Cowup, can we now turn to a report that you made for the Corporate Management Board? And if for that purpose, can we go back to your third witness statement where you referred to the gap analysis that was carried out for the purposes of PN 633? And could we therefore go to LFB 00119849/92 and the second sentence? This is the paragraph we referred to earlier on this afternoon in questioning. And you say in the second sentence of paragraph 207 this: the outcome of this assessment is described in paragraph 2 of the summary section of the report to ODCB. And then you mention that report is referenced elsewhere. Now, if we have a look at the report that was submitted to the Operational Directorates Coordination Board, ODCB, you're referring here, I think, to a report that you prepared dated the 17th of September 2014. Is that right?
If it's the report, I believe, I can't see it at the moment, but if
Let's go to LFB 00029895.
yes, that was, yes.
Thank you. Now, the purpose of the report is set out in the summary section on the first page and says this: on behalf of the Chief Fire Officers Association, CFOA, National GRA Working Group, London Fire Brigade played a central role in reviewing the generic risk assessment GRA 3.2 fighting fires in high-rise buildings, and this resulted in a significant amount of amendments being made to this GRA. At the conclusion of this work, Operational Procedures, OP, undertook a comparative review of the new amended GRA and the existing LFB high-rise policy and risk assessment. This review identified that the revised GRA contained a number of new hazards and control measures which were not reflected in the LFB high-rise policy. This comparison initiated amendments being made to the LFB policy, PN 633, to ensure it included the content of GRA 3.2. The new draft policy 633 has been consulted on with heads of service but is yet to be submitted to Brigade Joint Council for Health and Safety at Work, BJCHSW. So would it be correct to say that by the time you prepared this report in September 2014, the amendments to 633 had in effect been made?
Yes, I I seem to remember it was in a state of kind of mature draft state.
And this report essentially served as an update to ODCB about the new hazards that had been identified in the GRA and the changes that had been made to the policy 633 as a result. Is that a fair summary?
It is, and as it says in the next paragraph, the key reason for bringing the report was that I felt, having expanded our description of the risks, that we needed to think about the resources that we sent in the first instance to the fire.
Now, can we go to page 2, in particular the bottom of that page, where it says under the heading Analysis of GRA, it says this: a gap analysis between the national GRA and the existing LFB high-rise risk assessment and policy identified the following 17 new hazards, and this is the point you were just referring to in your answer. Now, we're going to come on to the risk assessment shortly, but can we look, for the moment at least, on the relevant new hazards, and that we can see the third one up from the bottom of the page is evacuation. Now, it may well be obvious, but I don't want to assume that. What did you mean by evacuation in this particular context as a hazard?
As it's described in the GRA 3.2. So if you look at GRA, and I can't remember the exact way we defined it, but that's what it's referring to.
And can you explain in more detail, please, why is evacuation a hazard?
Sorry, I can totally understand how that would appear really clumsy.
It's not necessarily clumsy, it's just Basically, unpacking the complexity of the topic, I think, is what I'm aiming to elicit.
It's referring to the hazard section of the GRA 3.2 and the fact that version 3 brought that issue of evacuation and the impact that firefighting can have on evacuation, and conversely the impact that evacuation can have on firefighting, recognising that can create issues and risks.
Why is it a new hazard?
The reason it's in inverted commas is because it's not a new hazard. It's been there for a long time. It hadn't been previously formally identified as a hazard so it probably does form part of 2011, because 2011 policy informed the GRA, but previously it wouldn't have been recognised formally as a hazard, if that makes sense.
No, I understand. Is it fair, or should the panel read into evacuation, that you're in fact here intending to convey the need for incident commanders to be able to carry out the evacuation of a building when stay put becomes untenable? Or is it not that limited?
It's not that limited, because it's in the context of the hazard section, it's as that is described in the GRA. When we wrote this, it was a bit of a shorthand for, there's some quite long subheadings in the GRA, and we've very much abbreviated that and shortened it down to one word, and I accept that as a result is confusing.
Given the understandable wish to condense material so it's digestible, for particularly in these types of reports, to what extent did you consider, when compiling this report for ODCB, whether you should condescend to the detail of the circumstances in which stay put becoming untenable and the wider implications of that decision for training provision for incident commanders? Was that considered as a precise particular issue that ought to be flagged up to ODCB in this particular context?
No, because as I've said already, the main aim of this report was to consider the predetermined attendance for high-rise fires.
When the report was submitted, were you pressed upon the nature and extent of the consequential new training needs that flowed from the new GRA 3.2 and therefore the new 633?
We certainly discussed training, and as I think the report reflects, there was a decision to delay taking it to BJCHSW, and I think that was to allow the training needs to be assessed, among other reasons. So yes, ODCB was a board of considerable scrutiny. So I'm sure we would have discussed training.
Can you help the panel as to why cladding systems are not expressly identified in this list of new hazards, given that they've been highlighted in GRA 3.2?
Well, to be clear, they weren't highlighted in GRA 3.2 as a hazard. Cladding is included within GRA 3.2 version 3 and indeed version 2 under the planning section, so it was not included specifically as a hazard.
And you didn't think there was enough information out there to flag it up with ODCB as being a hazard in the context of high-rise fires?
I can only repeat my previous answers, which is, and nobody regrets this more than me, that we did not recognise that material as a hazardous substance in its own right.
Can I turn to a separate topic, which is consultation and the first stage, according to the flowchart, which is peer review? Now, we've taken things slightly out of order because you referred to the gap analysis in your report to ODCB, which was in fact put together at the end of the consultation process for 633. 633. But I'd like to go back in time a little and to ask you some questions about the consultation process itself, to the extent that you were involved in that and to the extent there was substantive consultation.
Sorry, is this for 633?
Yeah.
Yeah, of course.
Now, we've seen on Appendix 3 the flowchart. The first stage of the consultation process was normally peer group review.
Correct.
Now, if we can go to your PC6 report, which is at LFB 000 327 83/29. If we look at paragraph 4.5.11, you say that consultation, this starts with a peer review within the owning department and can, where appropriate, include procedural testing arrangements, such as an operational exercise based on the draft policy. This option was utilised in the course of developing PN 633. Now, you then go on to clarify in your third statement at paragraph 205, which can be found at LFB 00119849/92. You say this, and it confirms the evidence you've given earlier on. I just want to take you to the statement. By way of clarification, the operational exercise was carried out in 2011, prior to the significant review of PN 633 in November 2011, which was driven by the lessons identified from the Lacknell House fire, and which was developed alongside the extensive process of national consultation review for GRA 3.2. And then you go on to say in paragraph 206 this: in light of that work, I determined that it would not be necessary to repeat this work again for PN 633 and carry out any additional peer review or operational exercises. So just to establish once for all, and I apologise, we do go over slightly the ground we covered before the break, but the operational exercise that was carried out in 2011 was based on the version of PN 633 that was in process or of being reviewed at the time.
It was based on the version that became published in November 2011.
Before the inquests into the Lacknell House fires?
Yes.
And before any substantive work on GRA 3.2 had started?
No, some work. I think there was an early draft of GRA 3.2 in existence around that time. Probably
the emphasis is on early, isn't it? And
it would be very early, but it would have been very reflective of all the work that we'd done for 633. So I think we would have done some of those structural changes in terms of the chronology of the information. So unpacking version 2 and putting it into a more chronological format. So I think there would have been an early draft, but it would indeed have been a very early draft.
So the operation exercise would have been conducted not on the basis of the final draft of 633, is that right? It's got to be.
Correct. It would have been probably a relative. I was talking then, by the way, about GRA 3.2 rather than PN 633.
I understand that.
But in terms of PN 633, given that that was published in November, the exercise was in June, July.
Well, it's more straightforward than that. The final GRA 3.2 was published in February 2014.
Indeed.
So
I'm thinking about when the operational exercise was held. I think it was June, July of 2000.
I think that's right. I think the definite dates you give here are that the significant review was the exercise was carried out in 2011. That's all you say, prior to the significant review in November 2011. My point was a more simple one, Mr.
Sorry.
Pratt, which I think is getting obscured, that the exercise in relation to PN 633 was carried out in 2011, which was obviously before the final version of GRA 3.2 was published in February 2014.
Correct.
Thank you. Now, would it be fair to say that in that case, it's unlikely that the exercise you carried out by way of peer review in 2011 covered those aspects, and in particular the points included by DCLG, which were included in the final version of GRA 3.2, which was published in February 2014?
it's certainly true to say it wouldn't have included the points raised by CLG. I would be less clear about whether it included the points other than that, because many of those were already in 633, i.e. the version published in 2011, and therefore I think a lot of the issues, certainly around fire survival guidance calls, failure. One of the things I remember the exercise tested, because again it wasn't in version 2 of the GRA, was a failure of the rising main. There was no acknowledgement in version 2 that you might not have a rising main, so I know they improvised an alternative way of getting the water to the fire floor. And moving the bridgehead, I think, was another thing that we did in the exercise, and again that was not envisaged in version 2. So some key elements were tested, but I wouldn't want to mislead the inquiry to think that the exercise tested every single nuance and innovation. It didn't. It tested certain agreed elements.
Well, it would have taken a fair degree of prospective insight to have tested against a document that hadn't yet been completed. And one of the matters which I suggest to you would not have been tested in 2011 was when and how incident commanders should carry out an evacuation of a residential high-rise building with a stay-put strategy in place. Is that a fair observation?
That's a fair observation. I wouldn't disagree with that.
Did you not consider that due to the significant changes that had been made to GRA 3.2 by CLG, it would be a benefit to design and carry out a fresh operational exercise that reflected those later changes when testing 633?
I think on reflection, and certainly with hindsight, I certainly wouldn't disagree with that. At the time, I didn't see that. So,
Can you give
the answer is no.
Can you give the panel an idea of the extent of your consideration of whether a fresh operational exercise was required in light of the extensive revisions to GRA 3.2, particularly those revisions actioned by CLG in the late stage of the process?
I think it's fair to say that I didn't give it any active consideration, and I can see on reflection that was probably a mistake.
Does the word active add anything there? Did you give any consideration to it?
I couldn't say with any certainty that I did, no.
So in terms of a process of peer review in relation to the draft policy 633 that was under review between 2013 and 2015, would it be correct to say that no peer review in fact took place?
I don't think that is a fair assumption, because my recollection is that the policy went to the operational sounding board, and that was a very effective mechanism for peer review. So that was something that I created partly as a response to the dysfunctionality of BJCHSW, because the views of frontline firefighters, in my opinion, were not coming through. So we set up this sounding board group, which was nominated representatives from fire stations across London Fire Brigade, and we used them to kind of road test and check the practicality of operational policy. And I'm pretty certain PN 633 was subject to review by the operational sounding board.
Can we come back to that sounding board element of the process you've identified there? Could I, before that, go to an email you sent on the 3rd of July 2013 to Andy Rowe, Jim A. Court, Patrick Utting and Philip Morton, which is at LFB 0011 8928. Now, if I can look at the top email, it's concerned with the head of service review of the draft policy. We're going to come on to that, Mr. Cowup, so I don't want to deal with that just now. I just want to deal with the headline point of this top email, in which you say this: for your information only, As I have decided that the volume and complexity of previous consultation for national GRA, on which the revised PN 633 is based, renders peer review a poor use of everyone's time. Nonetheless, this remains one of the most high-profile and significant policies we will promulgate this year, so you and your teams need to know it is coming. Now, looking at the clear terms of that contemporaneous email, would you now accept that no peer review process took place in relation to draft 633?
I'd contradict my own statement in an email if I said anything else, but subject to the review by OSB, which I know we're going to come on to, which I would count as peer review. What I meant by peer review here, if I remember correctly, was the review that would normally take place within ops policy. So that's the review within the policy leads. So they tended to look at each other's work on a peer basis. And that is what I meant in that context, in that email.
There's no reference in this email, though, to the ops sounding board, is there?
There isn't, but I'm very confident, because I didn't put everything in an email, that I would have agreed with Jim McCall and or Pat Uttin that we should consult on 633 via sounding board.
Now, this sounding board, when was it set up?
Good question. I think it was around 2012, 2013.
Who was on it?
So it was primarily firefighters, frontline firefighters from fire stations. I explicitly didn't want senior officers on it because they were consulted in other ways.
Senior officers being from what rank up?
Station manager and above. So it had no station managers or above on it. It did have quite a few watch managers, quite a few crew managers, and the greatest percentage was firefighters. We tried to make it reasonably representative of the operational workforce.
How many people sat on the board, therefore?
In total, there was about 120. For each consultation or for each review, we would select 15 or 20 to look at a particular document or a particular project.
How were those 15 or 20 selected, and by whom?
To take it back a step, the process by which the board was created was I wrote to the area DACs and invited them to make nominations. And I think I made it clear that I was looking for independently minded people, but constructive individuals who weren't going to come along and just throw stones at something. So therefore, it wasn't an open process that people could apply for. They were selected, and that was quite purposeful on my part. In terms of who selected the 15 or 20 for each policy, that would have been that would have either been the policy author, or I'm just trying to think, somebody was running. It was Tom Goodall. Tom Goodall was running the sounding board for me on a day-to-day basis, so he may well have done the selecting.
Can you remember now when the sounding board considered the draft 633?
I certainly can't remember the dates, but I'm confident they did look at it.
Can you remember now the detail, or at least the gist, of the response they gave?
No, because that would have gone to Tom Goodall and Pat Uttin.
It wasn't fed up to you?
I don't recall any feedback. I used to attend. We used to bring them in as a group, a big group, and I used to attend those meetings. And was there discussion of 633? I honestly can't remember, but they were a very positive, lively group. So they did a good job.
Can you remember whether their response caused any amendments to be made to the draft of the policy?
I can't, and I would suggest Pat Utting would be well placed to answer that.
Thank you. So we're coming up to 4:05.
Yes.
The next section that I want to come to will take half an hour or so, probably longer. I'm mindful that it's been a long day already. I'm also mindful that I'm nearing the end of my prepared questions anyway. What I'd propose, therefore, subject to your approval, is that we rise for today, now. I finish my examination tomorrow morning, and I anticipate that Mr. Cowup will be released in good time before lunch tomorrow. That also has the benefit of inviting those who've been watching to suggest any further questions they'd ask us to consider.
Yes.
For those to be ideally sent, I'd suggest before 7 o'clock tonight.
Well, that would be very helpful, I should think, wouldn't it?
It would be immensely helpful.
Yes. Well, Mr. Cowup, although Council has nearly got to the end of his questions, you probably know this, but we have to have a break at that point so that other people who are not here can suggest questions that we ought to ask you. So we shouldn't, I think, find it possible to get to the end of your evidence this evening in any event.
So it's not a problem.
I think it's best to stop early.
I'm very, very happy to come back tomorrow.
Well, that's very nice of you. So I think we will break there. It's a slightly early afternoon, but that probably isn't completely unwelcome.
Again, I'm not complaining.
All right, good. And we'll resume at 10 o'clock tomorrow, please. And it sounds from what Mr. Kinnear said that you can be pretty confident of getting away well before lunch.
The whole day tomorrow is yours if you need
Well,
it.
you might salvage some of it anyway.
If I do, that's a bonus.
Good. Well, thank you very much. Well, then, apart from reminding you not to discuss your evidence with anyone after you've left the room, that's it for today, and we'll see you tomorrow morning. Please.
Thank you very much.
Right. Thank you very much indeed. Right, Mr. Kinnear. Well, thank you very much. We'll stop at that point. It sounds as though you will finish well within the morning,
Yes.
and that will no doubt be welcomed by Mr. Cowup. Anyway, we'll see how we get on.
Thanks, sir.
10 o'clock tomorrow then.
Thank you.
Thank you very much.